RIA, and as one of the newest members of the team, I've already had the privilege of gaining valuable experience on both collaborative and litigation files, which has been really exciting. So today I will be facilitating our discussion, and I'm really looking forward to hearing the perspectives and expertise shared by our panelists. So today's topic is first steps after deciding to separate, which is a really cool way to start the new year, I guess. I feel like this is on a lot of people's minds, so it's a good way to start off, as this is like, key information to start your new year. So we would like to start with a disclaimer. Please note that the purpose of this series is to discuss general information on separation, divorce, and family law matters. Any information provided here should not be construed as legal advice. Also, we have a Q&A feature in Zoom here. So if you have questions, please submit your questions that way. If you have questions regarding your specific matter, we would suggest that you call our office or a lawyer in your area to book a consultation to receive tailored advice. Also, please stay tuned as we will be sharing how you can schedule a free initial consultation with one of our lawyers. Please let me introduce our panelists. Today we have Natalie Derbyshire, we have Rick Peticca, and we also have Gia Williams. I'll start with Natalie. I'll just do a quick bio on Natalie. Natalie is an experienced family lawyer. She has been practicing law since 2006 when she was called to the Bar of Ontario. Natalie is determined to practice family law with a view to improve dispute resolution options for her clients and empower them with the knowledge to make good decisions to foster, insofar as possible, financial stability, long-term peace, and happiness. She is also a certified collaborative practitioner and aims to save clients money. Oh, excellent work. And primarily recommending dispute resolution processes such as collaboration, mediation, and negotiation as alternatives to court whenever possible. I'm sure your clients love that. Rick is an associate here at RIA. He focuses on all aspects of family law and matrimonial laws by helping clients find resolutions on a myriad of areas, which includes child-related matters, support, property issues, and also drafting and finalizing domestic contracts, cohabitation agreements, marriage contracts, paternity agreements, and separation agreements. Rick is awesome, extremely experienced, and such a lovely guy to talk to. We also have Gia. Hi, Gia. Gia is an associate also at the firm with over a decade of solid litigation experience. She prides herself on being able to navigate challenging situations to create dynamic and sustainable solutions for all of her clients. Gia is passionate about helping families create child-focused parenting plans. Gia has spent over 10 years as legal counsel with a child welfare agency where she practiced child protection law, dealing with complex and highly emotional cases. She has also worked on cases that have gone to the Ontario Court of Appeal, the Divisional Court, and the Supreme Court of Canada. Wow, what a panel. What a lineup. So much experience. Thank you all for being here. I'll open the floor just briefly, just in case you guys want to say anything to our participants and, just so they can hear your voice to start.
Well, I'll say Happy New Year to our clients who are listening and
Mhm.
happy to be here and look forward to answering any questions that you may have for us.
Thank you, Gia. Appreciate that. I'll start the discussion with um, covering just a few steps that you can take when contemplating separation. Specifically, I think it's important uh, that when you're contemplating separation, you just reflect on this decision. Think about whether or not this is the right next step for you. Definitely will need to be engaging in conversations with your partner where safe and where possible. And also, I'm going to talk about briefly, just an intro about gathering financial information, um, as these are all important steps in ensuring that you approach separation thoughtfully and with the necessary preparation. So when choosing to separate from your partner, it's not a decision that you make lightly. It's definitely a decision that will impact not only your life, but also your partner's life, and if you have children, their lives as well. Before taking the significant step, take time to reflect carefully. So it might be helpful to start with an honest and respectful conversation with your partner. It's vital to approach this conversation calmly and in a candid manner, to express your thoughts clearly while also being willing to listen. This is not always easy, especially if emotions are high, but mutual understanding can help lay the groundwork for a more amicable process. Where this is not possible, you may consider reaching out to a counselor, whether it's a marriage counselor, if you're still exploring reconciliation, or if or an individual therapist that can help you yourself process your emotions. Counseling can help you better assess your ability to have meaningful conversations with your partner and identify what's best for your situation. So you want to be able to have trusted confidants that can help you just weigh your decision and sometimes clear out some of the noise that might be going on in your head. How do you guys feel about those first steps? Do you have anything to add?
Just
Yeah,
that they should also consider consulting with legal counsel because there are pretty far-reaching consequences from a legal perspective, financially, emotionally, psychologically. And as you noted, it impacts or has a trickle-down effect on family and sometimes third parties as well.
Thank you, Natalie. Rick, you had something you wanted to add?
yeah, I just wanted to kind of build on what you were saying, Jodeen. Look, separation is always a difficult issue, and it's a difficult topic, and it's a life-changing um, decision. And as you said, it's not something that's made lightly. But I think having that initial conversation just to see where everybody is at and having that respectful conversation without trying to rehash things of the past or trying to lay some blame already sets the foundation on how parties should be moving forward.
Of course. Yeah, thank
And
you.
I,
Yeah,
yep,
yeah, go
and
ahead.
I agree with all of you. And the one thing I also say to clients that I'd like to add is this is a very emotionally difficult time. And there's lots of things that need to happen. And then there is like the emotional part of it, the fact that your, life as you know it is sort of falling apart or you're moving into different directions. And there's the logistical things that sort of like, okay, now we have to do these things like figure out a parenting plan and figure out the financial pieces. And all of those are, like the logistical pieces that need to be dealt with. And you kind of sometimes have to separate like the emotion from
Mhm.
those pieces. And so, it's difficult to navigate it, but it would require you to be mindful and be thoughtful, to keep those things into perspective about the logistical things that need to happen as a result that you will have to address moving forward.
Thank you so much, Gia. That is such a good point, and it really feeds well into my next point about gathering financial information. It's such an important step in the process that unfortunately sometimes makes things really difficult for clients because lack of record keeping or just unable to really discern what belongs to who. And so that can make things really difficult. So one of the most important steps is, of course, in this process in separation, is to gather all the relevant financial information that you can put together. This includes income, assets, debt, expenses, and it's also important that you be cautious about moving out of the matrimonial home prematurely, as doing this can definitely affect your ability to make different claims. And so it's always important to consult with a family lawyer during this difficult time, because there are definitely rights and obligations that you have to consider as before taking that crucial first step of initiating your separation. So you'll need to start by collecting things like your pay stub, notice of assessments for the past 3 years, other income records that you may have. If you have income from investments, that's important as well. Because one of the most important things in family law is full and frank disclosure. And that just means like you have to be open with what you have, so that, and the other party as well, so that you can both be meeting on equal ground in terms of information to make accurate, helpful, meaningful decisions moving forward with your separation. So it's important to be honest. Now, whether or not that happens is another thing, but it's important. So also, I was speaking to Natalie earlier, and she mentioned something really important, is that sometimes we take for granted that, so our bank statements aren't just going to sit there forever waiting for us to collect them. I think the banks tend to destroy those records after like 7 years. Is that right? Yeah, so it's important to keep copies of those records, and not just hard copies, because who knows, they could get destroyed, or maybe your partner ups and leaves with them. It would be pretty prudent to ensure that you have electronic copies of these financial documents, because they will be important for reference later. Yeah, so I think one of the important things is, if you happen to be here and you're not going through a separation or thinking about separation, but you're in the initial stages of, starting a relationship or getting married, like definitely ensure that you know what's yours and what's your partner's. It's important that you determine ownership of certain things. You don't, because it's easy over time for assets and property to get intermingled and mixed, and when you're making a financial statement, it might become a hassle or a mess. Of course, these experienced lawyers can speak to that a bit more. I can open up the floor to you if you have anything else to add to that.
So I will say that in terms of talking about financial disclosure, I know that sometimes it could be very overwhelming for clients. And just so you know, you will have guidance through the process. So when you come to us and you're doing your separation agreement, and we will say, it's very important for us to start this process of financial disclosure, we will guide you through what you need to provide to us. So don't feel like you need to go out right now and start figuring things out on your own. You will get guidance around, this is what we're looking for from you. So take that, like if you have concerns around that, just take some comfort in knowing that you will get support through figuring out what you need to provide. Now, I do find that lots of times people question the need to provide financial disclosure. And they say, I know what he has, I know what she has, she knows what I have, and vice versa. And so we're fine. And it's important to do your due diligence, go through the process, do it properly, because you never know. Not having sufficient financial disclosure is a reason to overturn your separation agreement or challenge your separation agreement. And you don't want, after you spend all that time and money going through this process of doing a separation agreement, to have it like overturned later just because there wasn't proper financial disclosure. And also, you may feel like you know what the other person has, but you never know. You may not know. And so you want to protect yourself, and you want to go through that proper process of, doing that financial disclosure and doing your work, having it done diligently, and then, having some peace of mind at the end of the day that you've gone through the process and you have some protection knowing that you've done it properly. Those are what I wanted to add.
Thank you so much, Jan. Really appreciate that. That's your experience talking, making it nice and smooth and easy for everybody to understand. I appreciate that. So now that we have discussed how to reflect on your decision and prepare and introduce how you can prepare financially, it's equally important to understand the legal aspects of separation, and that would most definitely start with consulting a lawyer. So I'll turn this over to you, Rick. If you could share some insight on what individuals should look for when looking for a family law firm, that would be helpful to us. Thanks.
Thanks, Jodeen. So after you've considered the decision to separate, you've communicated that with your partner, you started having preliminary ideas of collecting your own financial information. The next step is moving to having a consultation with a lawyer, a family law lawyer in Ontario. And I always get this question from clients, what should I be looking for a lawyer? Knowledge and experience is important, and no doubt. And you want to focus on a lawyer that does family law regularly, so they're up to date with the case law, they're up to date with current trends and things that are going on in the area of family law. But most importantly, I think you need to find a lawyer that you click with and you connect with, because this is a very sensitive and very important issue and decision in your life. And you want to be able to have that rapport with your lawyer, that you can work with this person. This person can give you the knowledge, the guidance that helps you move forward in finding that resolution that you need. And you want to discuss options with your lawyers, like how are we going to approach my case? What makes my case so unique? Are there certain processes we should consider looking at? Should we consider looking at mediation? Should we consider looking at collaborative law, or perhaps court if that's required? So you want to be able to have these candid conversations with your lawyer and feel comfortable with him or her, so that they can guide you in that right direction.
Thank you so much, Rick. And Rick is awesome. You do a lot of the ICs, Rick. I know that, and you're very, very good to speak with. So look out for Rick, you guys. I'll turn to Gia next, who's gonna just talk about what those ICs tend to entail. Gia, you also do ICs too. Oh my gosh, you all do. You all do the ICs. Oh my gosh, this is great. These guys are great, just so you know. Okay, your turn.
Well, it depends on what the IC is about. So, let's assume that a client's calling in to ask about doing a separation agreement. So we will go through, I like to let the clients sort of let me know their narrative. I've already read your notes. I will have already read your notes, and more notes you provide, the great, because then I can have a better sense and we can like have a good conversation. And if the client is prepared with some questions, that's great, and I can answer those. And then I provide general information about things that I think may be relevant to them. So if that client does not have children, obviously I'm not going to be talking about a parenting plan. I'm not going to be talking about child support. But if they do, those are relevant issues to deal with. You can talk generally about potential for spousal support, and topics like equalization, information really for the client to be aware of, because we're not able to provide you with legal advice during a consult. It is a consultation. And so it's going to be sort of like high level discussion about things that you can expect. And it's also your opportunity to get a sense of, how I feel about the firm, how I feel about the lawyer, and is this, do I want to retain? And that's your opportunity to get a feel of how the connection you possible, an initial connection with the firm. And that's also helpful in your decision about retaining, because ultimately you want to not only, like Rick said, have someone who has knowledge, but that you feel comfortable with, and that that is you're going to feel supported throughout the process.
100%. And as you have mentioned, like this this process is extremely emotional, and I'm sure you have ICs that are quite emotional from the jump. Can you just tell us how you tend, or what's an appropriate way to balance those emotional challenges of separation while also, imparting on the client their rights and obligations and what they can expect to hear from the lawyer in those in that initial consultation?
Yeah. So while, I feel clients are very good doing a consult while it's emotional, but they also are wanting to use that opportunity to have information. So while they're emotional, they still have a purpose in mind. And we're able to sort of get to figuring out what needs to be done within that time, right? So it isn't, I've never had a consult where the client was so emotional that we couldn't get through the information that was needed. Clients are very good at sort of balancing. This is a difficult time, but at the same time, I have to be reasonable, and I know there's information that I want. There's certain steps that I need to take, and so we're able to sort of like go through that navigate that process in itself. So clients are good, and like you sort of take the lead as well from the client. But so yeah, that's my take on that.
Thank you so much, Gia. Appreciate that. I think I would go over to Natalie now, who's gonna speak with us about the ways in which you can, approach your situation, whether or not through litigation, mediation, what would be appropriate. Thank you, Natalie.
Thank you, Jodeen. So I really look at the array of dispute resolution processes as a spectrum, which we may recommend depending upon how amicable the relationship is between the separating or divorcing parties versus high conflict cases. There's also a number of other considerations that we might take into consideration, like a history of family violence, abuse, neglect, or a power imbalance that exists, for example. And so in the more amicable matters where people tend to have good communication with one another and perhaps a high level of agreement, we're more likely to recommend dispute resolution processes on the conciliatory end of the spectrum, starting with the collaborative family law process. This is one where the lawyers have received certified training to practice collaboratively. They each represent their respective clients' interests, and often we have more than just the lawyers at the table attempting to come to an interest-based as opposed to a rights-based resolution for the family. And these other professionals may be a neutral family professional who helps develop child-focused options to reach a settlement, as well as perhaps a financial neutral professional who typically helps try to come up with cost-effective solutions for the family, as well as alert them to tax implications, prepare calculations for them, and help devise proper financial planning and retirement planning for the family, as well as saving for children's post-secondary education. Aside from the collaborative process, which tends to be like transparent, and I like to view it as kind of an open-handed game of poker, if I can put it that way, we may suggest mediation as an option to families, and this is where there's a neutral facilitator of discussion involved who's helping both of the separating or divorcing parties try to come to a meeting of the minds. And then more often than not, we see cases where typically lawyers will first engage in standard negotiation. So both parties have a lawyer representing their respective interests and attempting to devise a separation agreement for them. In the more high conflict matters, we would likely refer the parties to either arbitration if they can afford it, where a private decision maker is selected, and it unfolds much like litigation would if you were attending court. And then, of course, the last resort, in my view, which is sometimes necessary, is attending court or litigating. So we just tend to take a pretty careful analysis of the case to ensure that we're properly matching our clients with an appropriate process based on cost, the type of relationship or communication that they presently have, and with knowledge and a view to what the set of circumstances are. It's a fairly fact-driven question that we need to respond to.
100%. Yeah. Thank you, Natalie. That is extremely insightful and very helpful for clients and potential clients to know that there are other options other than going straight to court. People tend to think, law, court, that's it. And there are issues there, sometimes there are issues that can be resolved outside of the court process, and maybe some issues have to be resolved within that process. As Natalie said, it's all fact-based, the approach that is right for you. So I will now move on to, I believe, Rick. For when there are kids involved, we're gonna talk about developing a parenting plan and what
Thanks,
that might entail. Thank
Yeah,
you, Rick.
thanks, Jodeen. So oftentimes when there's kids or there's children, family law lawyers will help parties develop a parenting plan that's child focused, and one that allows the child to thrive and allow them to have meaningful relationship with both parents. I mean, these are objectives that are set out in the legislation, the Divorce Act particularly. There's certain objectives, and when you're dealing with young children, even the very young children, you want to have a parenting plan in place that works. The more that there's turmoil, the more that there's difficulty, it impacts the children and it makes things a lot more difficult overall. And so oftentimes lawyers will work together with a view of putting together a plan that works in your particular situation. Not one parenting plan is the same. These are very tailored to every family. It's not a one size fits all. And so you have to be mindful of this. One tool that family lawyers look at are parenting plan guidelines that were established by the Association of Family and Conciliation Courts There's an Ontario chapter. The short form is AFCCO, and those were developed with professionals, social worker, family law lawyers, judges, family law judges, and that's a very helpful guideline, at least as a preliminary point in starting the development of a parenting plan, because it's age appropriate according to children of certain, depending on their ages, and it allows that discussion to, I would say, follow through nicely in terms of what to look for and what to include. I know Natalie mentioned before, if you're in the collaborative process, and typically in the collaborative process, if there's children involved, there could be a family professional that's engaged at that point there, where the family professional is assisting the parties in developing a parenting plan, and that's also useful and helpful in that process, and having a professional who's actually taking care of the parenting plan issues. So
Thanks, Rick. And I guess it's important also to note that these plans can evolve over time based on the needs of the family, the child, the children. And I was just wondering if you all can speak on that, about how, parenting plans may change, what that process may look like.
yeah, so I can add to that. Yeah, so a lot of times people think that these things are static, and you develop one plan, and that plan is supposed to take you right up until the child is 18 years of age, and that's generally not how it works. The younger the child, depending on the time of the separation, if you have very young children, it's understood that those needs will change over time. The child's needs will change as the child grows older, and so the plan has to be fluid. There has to be a review period that could invite the parties reviewing the parenting plan, depending on the issues, and adjusting, making changes along the way to accommodate a child. And that every child is different, and you want to have a parenting plan go into detail if there's certain specific needs or special needs for a child. That would also be included in the parenting plan as well. I'm not sure if Gia or Natalie want to add to that point.
Would either of you like to add to what Rick was talking about there?
So I agree with what Rick has said, and I think it's important for our clients to know that when you're developing a parenting plan, there are sort of various components to it. It's sort of determining, you have to figure out, okay, how a decision is going to be made for the children. Are we going to be making decisions jointly, or is one person going to be making major decisions? So you have to sort of figure that out. And then there is the parenting time, or what used to be called access, and sort of figuring that out too. And sometimes, everyone's well-intentioned, and, default position is shared parenting schedule. Sometimes that doesn't work. It doesn't work for your family, or the situation is such that, it cannot happen. And so you also have to be mindful of that. But ultimately, whatever plan is developed should be from the perspective of what's in the child or the children's best interest. And that should always be the focus. And like if things fall apart and you end up in court, you will know that will be the focus that the judge will be looking at ultimately. So always keep that in mind when you are developing your parenting plan.
Thank you so much. Yeah, that is such a good reminder that everything that particularly involves children has to be done in the framework of the best interest of the child. And I think something else I wanted to add was, pose to you guys is, when there are family professionals involved, how may that help? I think Natalie, you kind of touched on this a bit. How may that help parties work through their issues with coming up with a parenting plan? And in what situations might that be most appropriate?
I I think honestly, it's helpful to have a family professional at the table regardless of the dispute resolution process that's selected. I'm a big fan of having that neutral involved because it is an objective expert who's able to help the parents develop a successful co-parenting relationship. Often they act as a coach, although their mandate may be well defined. They may not take on various roles. It could be that they're providing, for example, an opinion to the court about what's in the children's best interests. But in a more amicable or conciliatory case, I find that having a neutral professional at the table means that often both parents have a better chance at being heard, of active listening being engaged in, and the child's views and preferences potentially being taken into account as a result of the family professional's involvement with both spouses, as well as diffusing and proactively resolving issues before they begin, if I can put it that way.
Thank you, Natalie. I'll stick with you as you were going to tell us about your how to secure our finances, reviewing accounts and things of that nature. Please take it away.
So often I say to people, do not touch your accounts, do not close your accounts before you speak to family law counsel, because a closure of your accounts may mean that there is no record, sadly, of the statements that are needed as a date of marriage or date of separation, unless you've kept those records or your spouse has. And so often we need to verify whether or not there's a financial status quo that needs to be maintained following separation. And you will need a lawyer to try to help you either agree upon or obtain a determination as to what the financial arrangement should be post-separation. So often there is an interim or a temporary stage of the matter where we're having to maintain the level playing field, or as I said, the pre-separation status quo of how expenses were being paid prior to separation in order to try to negotiate or have a determination made as to what the support arrangement should be and how property should be divided.
Thank you, Natalie.
I don't know if either of my colleagues wish to also jump in and add to that. You're welcome to.
Yeah, the floor is open, you guys.
I defer to Natalie's expertise.
Rick?
Yeah, I agree with Natalie and Gia. They've hit all the points. I guess one point is, and there's an assumption here that there's financial transparency. What happens in the case where there's no financial transparency? And I know Gia and Natalie, you've seen that before. There's some relationships where one spouse doesn't know how many accounts that the other spouse has, and so what do you do then, right? So this kind of does cause a problem because family law is premised on, as Jodeen said, full and frank disclosure. And if one spouse is intentionally, or perhaps not intentionally, not providing that financial transparency, it does complicate the resolution. It makes things drawn out, because you're almost on somewhat of a financial disclosure hunt and trying to determine what accounts does my spouse have and is everything being disclosed.
Yeah, when you're on the back foot, like where do you even start? So yeah, that's thank you for that addition, Rick. I will turn it over now to Gia.
Sorry, I think Natalie had another additional point that she wanted to make.
Oh,
I did. Thank you so much. I'm so sorry. I didn't want to
thank
interrupt.
you.
I was just going to also add that sometimes it's necessary for us to prepare a reconciliation of expenses post-separation. And so it becomes really important to have good record keeping of who's paid what post-separation so that we can keep track if there's potential reimbursements that may be sought. That's all. Thanks.
Thank you so much. And okay, I guess my question would be, what would you all suggest maybe where there's a lot of mixing of finances? What's the best step, best way forward to to address that?
Often, I would say it's helpful to have a financial professional at the table, and it depends on the set of circumstances. It may require the involvement of a certified business valuator to assist if they have business interests that need to be valued, or they're self-employed and there needs to be an income analysis, for example. But in other situations, it can be helpful just to have a chartered accountant or a financial divorce specialist at the table to assist. For example, for people who have experienced a power imbalance with financial information over the course of the relationship, sometimes it's helpful to have somebody assisting them with retirement planning or financial planning and an understanding of budgeting.
That's why you guys are the experts. Like, that's a lot of information, but please remember that this is also information that you will be repeated back to you should you do a consultation with a lawyer. This is information that you can definitely get from a lawyer as well. So don't feel too overwhelmed. These kind folks have been doing this for a long time, so this information just flows off their tongue. So please don't be too worried. Gia, I'll turn it over to you about creating a support network that during this process, as we have mentioned earlier, it's extremely emotional. I think I read somewhere where it's like it's up there with the death of a family member or losing someone. It's you're grieving something. So please share with us your
Yeah.
thoughts on this.
Yeah, and I was really happy when Natalie made mention of uh, possibility of domestic violence and things like that, because it is something to be mindful of. And if you are thinking of separating and that has been an issue that you've been a victim of, it is something to be very mindful of creating a safety plan if you are thinking about separating. And so that could involve a trusted family member or trusted family members. Or like a friend, and knowing, and especially if you have kids that are involved, it's important to also have a safety plan involved. Now we're talking about a support system. You're thinking about a support system, could be grandparents. If you're thinking about, and that may be relevant if you need childcare because you're separating and maybe during your parenting time, you're responsible for taking care of the children, and so if you're working late, then what's your backup plan? So, it's good to have a support system around. Like I said, it could be, like trusted family members to grandparents, friends, but it's key to sort of think about that moving forward.
Thank you so much, Gia. Definitely important to have those support systems in place. And that's helpful for all of us, actually. You never know what life is going to throw at you. So just ensure that you're pouring into people and they'll pour back into you as well. So I will move on to Rick, who's going to help us with the last topic of our discussion, document agreements and communication. Take it away, Rick.
All right, thank you, Jodeen. So as the process develops, obviously there will be discussions and agreements that are made informally. And obviously the lawyer will help you with this in confirming what agreements have been agreed to, at least in principle. And the ultimate goal here is to reach a final agreement, a separation agreement. And the assumption here is that we're trying to work out a resolution outside of court. And so if that's the goal, you want to keep thorough records so everybody is on the same page in terms of moving forward with the progress of the case or your case in your matter. And ultimately the goal is to reduce that final agreement into writing, that everybody can agree on those terms and that they can live by those terms. And as the lawyers are well aware, the goal here is we want to reach a meeting of the minds, that everybody's on board with, that they live with. And once you have a final agreement where everyone's in agreement, both in writing as well in the spirit of the agreement, it's less likely you're less likely to find difficulty down the road because everyone knows what to expect and they're likely to follow through. I often find sometimes clients will come to me and say, well, we can put our own agreement together, or I can download an agreement off the internet. And yes, you can, but those agreements, as Gia said earlier, if there's insufficient financial disclosure, they're more likely to be set aside. And I often find that those kitchen table agreements, you will run into a problem that was not foreseen. Part of having the lawyer is we've seen a lot of these cases. We know what problem areas are there, and developing a certain agreement that fits your separation so that the pitfalls won't be there, and would help you through in living by that agreement ultimately.
Sure, 100%. And I think with these agreements, of course, are designed to be long term. However, are there instances where parties revisit the agreements for some reason?
Well, there's issues that will need to be revisited. For instance, child support. If there's child support obligations, there will be provisions in the agreement that allow for a revisitation of child support. But on there may be other areas where there isn't. For example, on property, once the property is divided, that's final. So it's not intended to be revisited. So certain areas of the final separation agreement are intended to be revisited, reviewed, and varied, while other ones are permanent. And that's why it's important to have a family lawyer that you can work with that helps you finalize your particular separation and have that into a separation agreement.
For sure. And I'll just open this question up to the floor because you all have experience with this. Or I think you do. What happens when maybe you have an agreement in place and one party just says, no, I'm gonna do something else. um, how do clients tend to deal with that? What are the discussions like with your lawyer? What are the next steps? Like, should you jump in and make try to fix the situation yourself? What are we doing here?
Usually there are dispute resolution provisions in your agreement, which will specify what the process is that you are to enter into or what the steps are that you should be following to try to resolve the issue in dispute. If it's a clear breach of the agreement, then you should certainly be consulting with counsel immediately, because often that does lead to the need for intervention, at least by way of writing through counsel, if not by having a judge intervene.
Thank you, Natalie. Did anyone want to add anything else? I'm not seeing any questions. Oh, Rick, did you want to say something?
No, I think that Natalie hit the nail on the head. Basically, the dispute resolution provisions in the agreement will kind of point the parties in the direction. But I mean, as she said, it's always important to speak to the family law lawyer to truly understand how to approach that problem if
Right.
if a problem should arise.
And I
Yeah.
will add this, that it's important to be familiar with your agreement, right? Sometimes, people have those questions. This isn't happening. What should I do? And then we will point them to that provision in their separation agreement. So it's important to be familiar with your agreement and what it says about certain things. Yeah.
Okay. Um, thank you all so much for participating. It doesn't look like we have any questions. I'm just gonna just thank you everyone for taking the time to listen to us. We hope that this was helpful. Following the session, there will be a brief survey which will appear, allowing you to share your comments and suggestions for future topics you'd like us to explore. Again, your feedback will be greatly appreciated. But now to take advantage of this opportunity for a complimentary consultation with one of our lovely lawyers, some of whom you see here, please contact our intake team at that's INTACKE, sorry, at russellalexander.com. I'll say that again. It's INTAKE at russellalexander.com. And the code that you'll be providing to our intake team is NY 2025 to schedule your appointment. It seems like that's time. I wish you guys a lovely evening. Thank you for joining us. Thank you so much for your input. It's been a great and insightful conversation. I would say to the audience, please look to register for our next event. You can see that at russellalexander.com/family law now. There should be a list there of upcoming events. So yeah, we'll see you guys the next time. Thank you all.
Thank you to my friends. Thank you, Jodeen. Have a good evening.
Thank you, guys.
Thank you.
Have a good evening.
Have a good evening, everyone. Thank you.